Order. I call to order today's House of Commons Defence Committee evidence session on our inquiry into the Afghan Data Breach and resettlement schemes. When we discovered that there had been a super injunction in place for almost 2 years, many of us were shocked, especially parliamentarians, because we are often advised that Parliament is sovereign. And yet, parliamentarians were kept in the dark. I know that individuals within the media were not able to report, and that is why the Defence Committee felt very strongly that we needed to conduct an inquiry to get into the nuts and bolts of what had happened, what decisions had been made by whom, and in order to shed light on what has actually transpired. So I'm very, very pleased that we have with us today our three panelists from the media who were heavily involved over the last couple of years as to what actually happened within the Afghan data breach. We have with us Holly Bancroft. A very warm welcome to you, Holly. Holly is the Home Affairs correspondent for The Independent. We also have with us Larissa Brown, who is the defence editor at The Times. And I'm also very pleased to welcome Sam Greenhill, who is the chief reporter at the Daily Mail. Now, in order to set the context, and also, by the way, before we delve further, just a note for members that they should not be asking or compelling the witnesses to reveal any information that has been provided to them in confidence. That would potentially be an interference in court proceedings as well as a breach of confidence. Now, we were advised in the House on the 15th of July, the Defence Secretary made a statement to the House revealing that a significant breach of personal data of thousands of Arab applicants and their families had been made. The incident itself actually took place in February 2022, but was not discovered until August 2023, when we were alerted, or when the government first became aware, and it was alerted by an individual, a private citizen referred to as Person A. I'd also like to commend journalists for their grit, their determination, and their pursuit of the truth and to expose what happened. And I know that also, while he's not here with us today, David Williams of the Daily Mail was the first journalist to approach the government about the incident on the 17th of August back then, and I'm glad that he will be providing evidence to us at a later date. Subsequently, different journalists became aware of the data breach at different times, including Lewis Goodall of the newsagents. I know that all three of your good selves, as well as Lewis Goodall, were invited by the judge to address him directly during the course of proceedings. So that's the wider context, but we all know that this has had a massive impact on so many people's lives, those who had served not just our country, but those Afghans who had bravely supported our troops and our government. And that's why we owe it to them and their families to shed light on this. So let me kick off, if I may, and Larissa, we'll start with yourself, Ms. Brown. Now, you all wrote in July, when the super injunction itself was lifted, about the experience of being involved in court proceedings. Do you have any reflections now on, in the light of the passage of time, have you changed in any way? And if you can just speak regarding what you submitted and what your reflections are now, please.
Yeah, of course. I mean, it was obviously a really frustrating period for all of us. And this went on for, in some cases, 18 months, if not 2 years for some of us. And I think looking back, one of the sort of key moments was we were heading into the general election, and there was a small number of people that actually knew about what had happened, and I personally felt it could become an election issue. And I raised that with the judge in court in 2024, in I think it was January, February time. And what we knew was that the government of the day had put at risk potentially 100,000 people. In fact, the MOD's case, they were saying that these people could be at risk of death or torture. And we knew that they were making huge policy decisions behind the scenes, and obviously the public didn't know about that. This was at a time when there was a lot of discussion about immigration, yet they decided to secretly bring Afghans here who had been affected. And that was really concerning for us, because we believe that the public should know about that.
Yeah, that was under the ARR scheme.
There was, under the ARR scheme, the Afghan response route, that was a scheme set up to bring the Afghans here who had been affected by the data leak specifically, but Afghans did come in under different schemes as well. So that was sort of the first thing, is that we felt that the public should know. I was also, for me it was quite hard, because I had been campaigning for the Afghans for years to get more of them to the UK, those people whose lives have been affected by the Afghan war and their service with British troops. And I was in contact with a lot of them. In fact, I just published my book, The Gardener of Lashkar, which was about the Afghans and their plight. And I'd be speaking to these people, and I knew that their names potentially were on a list of thousands of people, and at any point the Taliban could get hold of their names and come knocking at their door. And that was really difficult for me, and I knew that I couldn't tell them about it, and they didn't know for the whole of this time that their names were on this list. That was something else that concerned me. And then also, as defence editor for the Times, I was writing about what is the MOD going to do with all this new money for defence, and yet I knew that they were planning to spend billions of pounds on handling this fallout. So when I was writing they could spend money on this, I was actually thinking, billions of pounds of this might be going on the data leak itself. So those were the things that I found particularly challenging, and I also tried throughout this process to try and hold the government to account for what was happening, and try and find a way of writing about it without breaching the terms of the super injunction. And the only way I was able to do that is to write about General Sir Gwyn Jenkins at one point, because he had been asked by a minister if he was going to resign over the issue, and I was able to write that the issue he was asked if he would resign over was a national security incident. And that was all I could write at that point. But I think we all were just desperate to get something into the public domain so people could know what was going on in some way, but obviously we were really restricted.
Thank you very much. Mr. Greenhill, further to your reflections that you set out in July, with the passage of time, any other things that you would like to place on record, please?
Well, certainly I'd echo everything that Larissa said. But since July, on the 15th of July, John Healey proclaimed himself deeply uncomfortable at the lack of transparency. And I think he said to all the MPs that after 2 years of secrecy, all that would change. And I think we've all found that in the period since then, it's been something of an uphill struggle to get answers to basic questions out of the MOD. Several of the emails questioning things that I've sent to the MOD have simply been ignored. And on one occasion, I eventually resorted to an FOI just to simply find out a date, which took 4 months eventually to get, but I still haven't heard it from the MOD press office itself. So in terms of has anything, you wonder if anything has changed since 2023 when the MOD so alarmingly easily slipped into a most unprecedented...
It's very disconcerting to hear that you still feel that there's a lack of transparency from the Ministry of Defence to the questions that you are posing.
Yes, well, some questions have simply been ignored with no explanation.
Okay, well, no doubt we will come on to these issues. By the way, during the course of our session, whether it's in terms of the impact of the secrecy, whether it's in terms of resettlements, whether it's accountability, so we will be delving into this. Members have got different areas that they do want to focus in on, including risk assessments. Ms. Bancroft, what are your views further to your submission in July, and what else would you like to place on record at the outset, please?
I think kind of post the super injunction being known about, it just came to me, it kind of has been imparted to me that the whole process was something we couldn't go away and ask external experts for their views. We couldn't get answers to questions because we were under a super injunction. The MOD also didn't want to investigate anything that was presented to them. There's many examples of caseworkers bringing examples to them that weren't investigated. They also didn't, until the RIM review, go to any external experts. So the actual court process itself was a lot of hypothetical exercises as to what might be the case if XYZ happened, but not being able to rely on much actual external expertise. And I think kind of having it being lifted and also the exercise of the RIM review, does shed light on some of the issues. And I think it just shows me what a kind of very closed process it was, that it's not actually possible to, during that process, to kind of have basic answers to basic questions. And also the MOD wasn't investigating to find out basic answers to basic questions. And then also, one thing I am personally concerned about since the lifting of the super injunction is the movement of people out of Afghanistan and out of Pakistan. Seems to me to be very not happening very much. And I don't know the answer for why that is, but I think you guys should try and find out as to what has slowed down the process of evacuation. Why is it kind of become very difficult to get people out?
Ms. Bancroft, your views are duly noted, and let me reassure you that the committee has every intention to conduct a comprehensive inquiry, and during the course of the coming months we will be taking evidence from many of those who were involved and trying to get to those to the bottom of things. But my colleague Lincoln Jopp wanted to come in on this particular point.
I did. Thank you, Chair. I want to go all the way back to the breach itself, if I may. In your investigations, your dealings, can you give us a sense of the extent to which it was just an assumption that it was a cock-up, or that did anyone entertain the notion that it had been deliberate?
Well, this is actually really important because we were never told how the leak had happened. So we were going into an election period where it could have been a minister for all we knew. We had no idea how it transpired. So sort of we did investigations over that time, didn't we?
We did, but I mean, right at the very beginning, in August 2023, when you mentioned my colleague David Williams found out about it and asked the MOD, the first thing he was told by somebody was that it was being considered as possibly a malicious leak, and that a hostile state actor, potentially Iran or Russia or the Taliban, could be involved. That's what they were looking at initially. Obviously, that was then ruled out, but we never got to the bottom exactly of what had happened, other than that, I believe it was a mistake by a soldier, right? I mean, personally, I wouldn't blame that soldier. I mean, we all sent an email in error, but there was obviously a systemic problem that caused.
But no one ever considered that it might have been that soldier doing it deliberately, is my question.
No, I think I had sort of throughout quite early on, I found out what had happened, I think, and I knew that it wasn't a malicious. Well, from my sources, from what the problem was, is we couldn't ask a lot of questions because obviously we were bound by the terms of the super injunction. So we could only speak to people that we also knew about the super injunction. And I was led to believe quite early on that it wasn't a malicious act, and it was somebody that had done it by mistake, in error, and that person was actually really trying to help the Afghans, and there was a mistake done.
Right.
We didn't have the details.
Thank you very much.
Yeah.
Right, let's continue delving further into the super injunction with my colleague Alex Baker.
Thank you, Chair. So we're going to delve into some of the detail now. So what do you think each government got right, and what should each government have done differently in respect of this legal process? Who would like to start?
I would say, I think initially the right approach was secrecy. I think that it was obvious they were dealing with a monumental blunder. There were lots of unknowns. There were huge numbers of lives at risk, and I think that was right to start off with a secret process. I think Larissa's completely right, and she made this point in court to the judge, that when we got to the general election, the judge was saying that the super injunction should be lifted the special advocates, remember they're the KCs who are security cleared, they've seen all the secret material. They were saying there was no justification for it. That's when I think that there should have been, that was the inflection point where the government should have realised that they needed to abandon their stance on the secrecy. Obviously then we had a change of government, and pretty much business continued as usual to begin with, until we got to November the 11th last year, nearly a year ago, when we had a slightly different change in tactic by the government, which I can go into great detail on, but it's essentially that they changed the mood from one of we must have complete secrecy to you, the press, need to remain silent while we, the government, release selected cherry-picked information to the public.
So was that October or November? Because there's two. There's a HEA meeting.
So there's a HEA meeting in October, correct, and then in November we had one of our hearings in which we learned the detail of that meeting.
Thanks.
And is there anything either of yourselves would like to add in terms of what the government got right and what they didn't get right?
I personally think that the exercise of rumour should have been done far earlier than it was, because, I think it's a question of we need outside expertise to assess some of these issues, and I think rumour did do that exercise without disclosing key information. So stuff like the general picture of risk in Afghanistan is something that I think you need to establish with, people like the UN, try and get that sort of expertise in from the minute this happens, really, personally. And there wasn't really a desire to do that. I think also we saw throughout the whole process in terms of response to the breach itself was very slow in terms of setting up a resettlement scheme, how many people you're going to help. Like, that was part of why we got involved, was that it took 4 months, 5 months from the breach actually happening to them turning up and saying, oh yeah, we're going to help 150 people. Just like, what? This is so slow. And we kind of felt compelled to get involved in order to kind of hold the MOD to account on setting up whatever it was that they were going to do. So I think part of that is due to the structures of government, how that worked. And, we would often find out that ministerial meetings would happen like just before we went to court, so that there would be like something to tell the court. So that kind of seemed to be an impetus as to making stuff happen. But I don't know how about, Larissa?
Yeah, so the super injunction, I think, was in place for far too long, and Healy, Secretary of State, should have ordered that review sooner, in my opinion, the RIMA review, because that wasn't ordered until I think it was January this year, was it? Earlier this year. That should have happened way sooner. And then in terms of the previous government, there were questions about whether there should have been a super injunction at all. In fact, RIMA even said in his review that it might have essentially made matters worse because it increased the value of the data set to the Taliban. And some people I've spoken to would probably argue, well, did they need it in the first place? If they just had a story in the Daily Mail as a result of David Williams at that weekend, would it have gone unnoticed by the Taliban, and that would have been the issue dealt with? I don't know the answer to that, but when Ben Wallace applied for the injunction to begin with, he thought it should be a time-bound injunction, and what we had was an indefinite injunction, and we saw no end date to it.
Well, we will be going further into the RIMA review, so we'll leave the questions on that for the moment.
I'm interested in this idea that there could have been a different way of doing this, and actually, acknowledging, the lack of accountability that has gone on in all of this. Do you think that there could have been a way where, there could have been, provisions put in place, for the secrecy, but then, briefing, for example, the Intelligence and Security Committee, so that there was some sort of basis of accountability within the process?
I was really surprised that the Intelligence and Security Committee wasn't briefed. Obviously, that committee is designed to be able to handle the most sensitive matters, and in fact, intelligence from the Defence Intelligence Unit in the MOD. So we had this was raised in court, and the MOD suggested that they didn't need to be briefed. So I'd be really interested to see what were those discussions behind closed doors.
And then, so I mean, obviously, as it stands, you were the only people that were left to actually make the checks on what was actually happening. What does that tell us about where the gaps in oversight are when governments take on unusual steps like they have done in this case?
Well, the Special Advocate argued that the democratic process was in the deep freeze, and that was true because you're right, we were the only people that were actually holding the government to account or trying to hold them to account. But throughout this process, we weren't allowed into the closed hearings. So actually, we were doing this with our hands tied behind our backs because we couldn't make well-informed arguments without knowing what the MOD justification was for the super injunction in the
And the
first
special
place.
advocates who did have access to all the secret material, they weren't making inquiries with people in Afghanistan or in the UK Afghanistan community that we would make. So there was nobody really, apart from the MOD themselves, who could check stuff out and know all the background. And that is a problem, that is a gap. And I don't know what the answer is, other than there should possibly be a rule that super injunction shouldn't last for any longer than a set period of time or something, in order to force them to come out and be a bit more open initially.
Thank you, Chair.
Thank you very much. Jesse Norman, please.
Thank you very much indeed for coming in, and thank you for your testimony. Just want to pick up some of the points in the legal process that was undergone. Now, Larissa, you've mentioned that there were private hearings, so there were reserved hearings, or hearings to which you were not admitted. So we're building a picture of hearings which are private but open, that is to say the defendants can be there, private but closed, that is to say secret information is shared. What is so striking is that it seems as though the judge decided in his own judgment initially, not on a petition, that this should be a super injunction, that it should be global, and that it should be indefinite. Is that true?
No, that's not quite right.
Okay, thank you. So if you can put us straight on it, I'd be very grateful.
As I understand it, he did indeed upgrade it from an injunction to a super injunction.
Right.
But it was never indefinite. The MOD had asked for 4 months in order to take some protective actions, rescue people. And it's just that after that 4 months, they asked for an extension. And then
So pause for a sec. So the MOD didn't seek the super injunction, the MOD sought the injunction.
That's true.
And
but with the caveat that ever since they got the super injunction,
No, you understand.
They didn't want to lose it.
To be clear what the facts are. Originally, the MOD applied for injunction. It was an upgraded to a super injunction. They thought, oh goody, we'll reapply for a super injunction when it occurs. But originally, they'd only asked for 4 months.
Correct.
They then reapplied, and it was granted.
It didn't have to reapply, it just rolled on. Well, there were hearings, and the judge wanted to weigh up various
There are
things.
hearings, people are speaking to this from different parts. You're getting a chance to cross-examine the people coming in and speaking to the judges.
Eventually,
The judge,
yes.
okay.
But it rolled on over and over. And in fact, the judge himself, in his judgment of May 2024, when he said he was going to lift the super injunction, made the point, I have to grasp the nettle, otherwise this will just go on indefinitely.
Okay. Okay, great. So then the High Court wanted the super injunction to be discharged, and the then Secretary of State appealed that. Have I got that right?
Yes.
Yeah.
Okay. And what was the reason why the government, in your judgment, chose to appeal at that point? And why do you think it was so tame, the super injunction aspect?
I think the obvious answer is they felt it was offering great protection to their teams operating on the ground, and no doubt it was. But in terms of why they appealed, I mean, we don't know exactly because the appeal court heard an entire day of submissions and I believe fresh evidence from the MOD entirely behind closed doors. We weren't in there, so we don't know exactly what they presented to the appeal judges. But obviously by the time we got there the next day, it was obvious that the MOD had given a very convincing case. So but taking it at face value, it's because it was offering protection for their teams on the ground. It was, of course, right in the middle of a general election campaign.
Yeah, okay. I mean, the decision was made before the election was called. So the judge had no reason for thinking the election was going to get called.
Hang on. The May 24, when was the election called?
It was
May 24.
It must have been
early
called
June.
in May.
Early June.
Yeah, early June. Was it? Okay, so yes.
I mean, I don't think it's, sorry, there was a slight suggestion there might be political.
Yeah.
We knew it was
influence,
coming.
and I don't think we can. I think we can discount any political suggestion. The judge wasn't being influenced to protect either way by any politician in relation to the general election.
The judge.
No.
Okay.
No, that wasn't the factor. The only, if you wanted to say there was any political interference, it would have been about whether or not to have an appeal, not the substance of the appeal.
Right. Okay. So they had an appeal and it was successful. They then didn't appeal it further to the Supreme Court.
They meaning the press.
That's right.
Yes.
You didn't, I should say.
No, we didn't.
And the question is, why is that?
I'd say a number of factors. I mean, some of it was legal advice that we can't discuss, but it was also...
Grounds didn't exist. It looked good in law, as it were. There was no arguable case to be made in the Supreme Court. That'd be the kind of argument.
Yeah, I think it was, and of course we hadn't seen any of the evidence they'd given to the appeal court judges. So how are we supposed to fight without? We would be going in totally blind.
Okay, brilliant. And then just a couple of other quick things. So obviously they then, before this, it's already been, the super injunction has been extended to cover this secret settlement, this new settlement regime, the ARR, if I've got that right, with potentially enormous further costs. So there's a significant expenditure of public capital being covered by the by the super injunction, as well as all of the proceedings designed to protect individuals in theatre. Is that right?
Yes, billions of pounds.
Yeah.
And you see that in some of Chamberlain's judgments. He's starting to think, how is it actually possible to keep this huge process secret?
Right. There's an enormous machinery of government
exactly.
going on around the ARR, which is being kept secret by the super injunction alongside all the other material.
Yes.
Yeah.
Okay, thank you. Final point would just be to note a point, which is we have detected a change within this committee. I think it's public record in the quality of information we've received from MOD, which has not just got worse, but has become structurally worse in the channels that they give us. And I've questioned the Secretary of State on this issue, and I've no doubt, without putting words to the Chairman's mind, it'll be something we think about in future. So thank you for your remarks about that. When the Secretary of State appeared in front of us, just for information. So thank you. Thank you, Chair.
Thank you very much. Okay, let's now move on to the impact of secrecy with my colleague Fred Thomas.
Thank you, Chair. Secrecy is quite a burden to have. You had that for a long period of time, which you're used to as journalists because you protect your sources, so you have some element of secrecy anyway. The judge in July of this year, in the judgment, said that it was a remarkable feature of this whole situation that there had been no mention in the media of the underlying matters for the several years that the super injunction remained in place. Larissa, you've just mentioned earlier, I think, that maybe he got that wrong because you were able to allude to a national security incident when asking General Jenkins a question. However, notwithstanding that, the judge thought it was remarkable that despite a super injunction, none of this came out in the media.
That was approved, by the way. The MOD said we could write that. That wasn't me trying to breach the terms of it or anything like that.
Yeah, that's clear, and that's on the record. That's on the record.
He did say that. It was words to the effect of he was astonished that we'd kept our traps shut for 2 years.
Yeah, so my question to you is this. Do you think he means he's astonished that you, the media, kept your traps shut, as you say, Sam? Or do you think he's alluding to parliamentarians, where we as MPs have parliamentary privilege, so under the Bill of Rights, you can't put an injunction on us? Well, I wasn't there at the time, but the previous Parliament. Do you think that he's alluding to that and surprised that no one in Parliament raised this?
No, in his judgment, he was specifically talking about the media. But, elsewhere in the case, he was certainly incredulous, I would say, at various other aspects of what you're talking about, which is why Parliament was being kept in the dark. But, keeping that secret for all of us was very hard. And as Larissa said at the beginning, the hardest part was when we were speaking to Afghans, and Holly, I'm sure, had exactly the same experience, knowing that they were potentially in danger, but we were unable to ask them if their names might be on a list. We couldn't say there had been a list that had been leaked, that their details may have been lost. These are people who were being raided by the Taliban sometimes. They had family members being rounded up, and we simply weren't able to warn them, we weren't allowed to warn them. And that went on for nearly 2 years, and that was very difficult. I mean, my colleague David Williams says, since July, lots of translators have said to him, why didn't you tell me, David? My mother was beaten. I could have done something if you told us. And it was very, very difficult to keep that secret.
Must have been hugely challenging. Yeah, Holly, do you want to touch on that? Give us a sense of the professional and emotional strain that this super injunction put on you guys as reporters.
It was really tough. I think initially when I first got served with the injunction, I kind of thought, I'll put examples to the MOD and I'll try and email them with cases. Is this phishing email because of this leak? This person's had this happen to their family, and I would try and email them and say, can you look into this? And then that quickly became apparent that they weren't going to do anything with anything that I was emailing them. So I kind of stopped doing that. There was a bit in the initial part where, because I kind of got into this because they were evacuating some people, and there was a process I found really stressful where they gave people eligibility and then took it away, and knowing the background to all of that was really hard when you're trying to raise people's cases, but then you're also thinking I don't want to raise certain information if it's information that's been shared with me privately. I shouldn't share it. But so there was a real tension of I don't want to share a lot of stuff in a court case that they don't know about, but how do I represent their interests, and how do we kind of raise their voices in that forum, because that was lacking in this whole process. I think, touching on what you said about kind of Parliament, I think the judge, particularly with Parliament, became quite concerned about the use of parliamentary statements being made to provide cover. So there was an instance where the Secretary of State made a statement to Parliament to provide cover for the secret scheme that was happening.
What do you mean to provide cover?
So essentially, he gave an update about the Afghan settlement schemes and the plan to close them, and that was to provide an excuse for the MOD to explain to councils, for example, why there's suddenly people arriving in their area. And so a parliamentary statement was used to explain, we're merging the schemes, it's going to be called this, and therefore that's what we're going to use to tell councils and MPs what's happening. And that was submitted to the court. This is our plan to provide cover by using this statement. And that was something that I know the judge was quite shocked about when it happened.
That was the time that